Assalamualaikum. In behalf of our group, Mindalano Raihanati, Dero Nurjana Lumundot Abdul Gafar is, and yours truly, Ayaon by Sahara P, we are going to present and discuss to you the Juvenile Justice and Welfare Act of 2006 or the Republic Act number 9344 as amended by Republic Act number 10630. Juvenile justice system is a system dealing with children at risk and children in conflict with the law. It provides child-appropriate proceedings including programs and services for prevention, diversion, rehabilitation, reintegration, and aftercare to ensure their normal growth and development. Republic Act number 9344 observes the principles of restorative justice wherein it is a process of resolving conflicts to obtain reparation for the victim, reconciliation of the offender, the offended, and the community, and provides reassurance to the offender that he or she can be reintegrated into society and serves the best interest of the child to conditions which are most favorable to the child. Who are covered under Republic Act 9344? They are the following. First, the children in conflict with the law or the CICL. They are the children who are alleged as, accused of, or adjudged as having committed an offense under Philippine laws. Another one is the children at risk or the children who are vulnerable to and at the risk of committing criminal offenses because of personal, family, and social circumstances. They are also the children who are abused, exploited, abandoned, neglected, out of school, street children, gang member from broken or dysfunctional family, living in community with high criminality rate and drug abuse, and those children living in situations of armed conflict. For clarification, children at risk are not yet offenders, and Republic Act 9344 serves to prevent them from becoming one. Who is exempted from criminal responsibility? They are the following. First, a child 15 years of age or under 15 years of age but below 18 years of age who acted without discernment, and the child shall be subjected to an intervention program or it is mandatory and does not include exemption from civil liability.
Discernment is the mental capacity to understand the difference between right and wrong and its consequences. So the bases are the facts and circumstances of the child, the educational level of the child, and third, the appearance, attitude, behavior, comportment of the said minor before and during the commission of the act, but also after and even during the trial. The following are the measures that may be undertaken by the law enforcement officer to determine the age of the child. First is the presumption of minority. Second is the documentary proofs such as birth and baptismal certificates and any other pertinent documents. Third, information from child himself. So interviewing the child and obtaining of information that indicate age by date of birthday, grade level in school. Fourth, the physical appearance of the child. And fifth, the doubt to be resolved in favor of the child. What happens when a child in conflict with laws commits an offense? So in the initial contact with the child, the law enforcer shall determine the age of the child. So if the child is 15 or below, he is exempted and shall be released to his parents or guardians. If the child is above 15 and below 18, his discernment shall be determined by the LSWDO. So if there is no discernment, the child is exempted and shall be released to his parents or guardians. However, even if they are exempted from criminal responsibility, they shall undergo intervention programs to prevent them from committing another offense or from becoming repeat offender. What is diversion? Diversion is an alternative, child-appropriate process of determining the responsibility and treatment of a child in conflict with the law, on the basis of his or her social, cultural, economic, psychological, or educational background without resorting to formal court proceedings.
If the child is above 15 years old but below 18 and who acted with discernment, he shall proceed to diversion where parties involved in the offense come up with an agreement that will benefit them, such as conflict resolution or mediation, formulation of diversion program, and acceptance and signing of contract of diversion. Children in conflict with the law shall undergo diversion programs without undergoing court proceedings, subject to the conditions herein provided. First, where the imposable penalty for the crime committed is not more than 6 years imprisonment, the law enforcement officer or punong barangay with the assistance of the local social welfare and development officer or other members of the LCPC shall conduct mediation, family conferencing, and conciliation. Second, in victimless crimes or offenses with no private offended party, where the imposable penalty is not more than 6 years imprisonment, the local social welfare and development officer shall meet with the child and his or her parents or guardians for the development of the appropriate diversion and rehabilitation program. Where the imposable penalty for the crime committed exceeds 6 years imprisonment, diversion measures may be resorted to only by the court.
Contract of diversion. So when a child voluntarily admits the commission of the act, a diversion program shall be developed, and it must be in writing and signed by parties and concerned authorities. The local social welfare officer shall supervise the implementation of the diversion program, and the diversion proceeding must be completed within 45 days. If the CICL fails to comply with the terms and conditions of the contract, the offended party may institute legal action against the CICL. Now, what happens if the diversion did not work or the conflict resolution or mediation between the offender and the victim fails? That's where prosecution enters. Prosecution also applies to CICLs who have committed an offense that are punishable by more than 12 years of imprisonment. In prosecution, there will be delinquency proceeding, advisory or preliminary hearing, trial, and disposition. If the CICL is found guilty, he will be placed under suspended sentence until he turns 21 years old. That's when he could start serving his sentence. Bahay Pag-asa. Children in conflict with the law who are above 15 and below 18 years old, who are awaiting court disposition or transferred to other agencies or jurisdiction, shall be placed in the Bahay Pag-asa. Bahay Pag-asa have intensive juvenile intervention and support center to cater to children in conflict with the law who are above 12 years old but below 15 who committed serious crimes. These serious crimes are parricide, murder, infanticide, kidnapping and serious illegal detention where the victim is killed or raped, robbery with homicide or rape, destructive arson, rape, or carnapping where the driver or occupant is killed or raped, or offenses under RA 9165, otherwise known as Comprehensive Dangerous Drug Act of 2002, punishable by more than 12 years of imprisonment. These children who have committed such serious crime shall be deemed neglected child under Presidential Decree 603. Now, Youth Rehabilitation Center. CICL under suspended sentence shall be placed in a youth rehabilitation center where he will undergo rehabilitation or disposition measures. If the CICL fulfill the disposition measures, imposed by the court, his case shall be dismissed upon the recommendation of the social worker. However, if he fails, he shall be brought before the court for execution of his judgment. Aftercare. CICL whose cases have been dismissed because of good behavior shall be provided care services by the LSWTO, counseling and other community-based services. This is to facilitate their reintegration and to prevent them from re-offending and to make them productive members of the community. That's all. Thank you.